Today is January 20th, and you have the only argument that we will be hearing this morning. Your panel today is myself, Judge Teodosio. I'll be presiding. As you can see, Judge Sutton is with us this morning, as well as Judge Callahan. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. And if you're going to reserve time for rebuttal, if you would please just let Judge Callahan know, and she'll let you know as you get close to your rebuttal time, into your rebuttal time. The argument is visually and audibly recorded, and as you know, we are live streaming. So it's important in this case that we refer to the parties as husband and wife only. So we don't want to hear any names. It's just husband and wife. And there's no minors in this case, so I think that should take care of it. All of the judges have read the briefs in this matter, and we are prepared to proceed when you are. So, Attorney Rich, on behalf of the appellant, would you like to reserve some time?
Yes, I'd like to reserve 5 minutes, please.
All right. Thank you. You may go ahead then. I'll proceed.
Your Honors, my name is Jonathan Rich. My colleague, Christopher Reynolds, and I represent the husband, who's also the appellant in these two matters. Your Honors, nearly an identical case in terms of the fact scenario decided by this very same court 2 years ago in the case called Santa Mora versus SUMSS Property Management. This court upheld the settlement agreement that the parties reached and read into the record at the trial court level. Those are really the exact same facts in the case that you are deciding today.
Isn't it different in that? Isn't it different in that in this case you had the agreement in municipal court, and there wasn't an entry in municipal court, and then you're also dealing with a second court in the domestic relations court in this case? If I recall, in Santa Mauro, that was not the case. Is that a distinguishing factor?
I don't think it's a significant distinguishing factor. So in both cases, the agreement was put on the record. The parties were there, the attorneys were there, they recited the agreement into the record, and eventually that agreement was enforced by the courts. Yes, it was done.
Hang on for a second. When you say that agreement, I apologize, was enforced by the court, do you mean domestic?
I'm talking about the Santa Maura
okay.
case.
All right.
In that case, the agreement that was just orally recited by the attorneys on the record and agreed to by the parties was enforced by the court.
Is it your contention? Is it your contention then that domestic relations court had the authority to enforce an agreement that was made in municipal court?
It was an agreement, period. The place that that agreement was formed or where the oral exchange was made is irrelevant. The fact is the agreement was reached. It happened to be reached in the municipal courthouse, and it happened to be put on the record in front of a magistrate in that court. But the agreement is what is important, not where the agreement was made. And I'll tell you that the Santa Maura case had a similar fact in that the parties settled a case in a common pleas court. It was regarding the dissolution of business, and it was like a family dispute with relatives. And one of the terms of the settlement that was put on the record in that court had to do with an estate. And so that was a term of the settlement in that case that had nothing to do with that particular case. And that was another term that was put on the record, and it was an enforceable term. There were parties in that case that were common to the estate, and they were going to waive an interest that some of the relatives had in the estate. And so I see no difference between the fact pattern in that case and the fact pattern in our case. The agreement was essentially—
Let me pose you this question then quickly. Which court had the authority to enforce the settlement agreement?
the settlement agreement was designed to be enforced in multiple courts. The parties made an agreement to settle various cases. The fact is that that transcript is just evidence of their agreement. The agreement itself is what is important, and they agreed to settle multiple cases. They agreed to settle their case that was pending in the municipal court, and they agreed to settle their case that was pending in the domestic relations court. There was also agreements regarding a divorce that happened in England, and various obligations that may have arisen under their divorce decree. And they agreed to settle those issues as well, or not to raise them and to release them. That was part of the agreement. There were several reasons that the trial court gave for not enforcing this agreement that was reached. And in the domestic relations court, the magistrate that heard the case said that the Akron Municipal Court did not have authority to enforce issues that were resolved in the other court. And again, that goes to Your Honor's question about the location of the agreement and where it was formed or expressed. The bottom line is there was no decision by that Akron court that the Common Pleas Court was asked to enforce. This was an agreement, not a decision. So there was no like assumption of jurisdiction over another court's decision.
Well, can I ask you a question then in that regard?
Yes.
There was no decision by the Akron Municipal Court with regard to the Muni Court case. It's the deck action ruling you're appealing, correct?
Correct.
What was there for the municipal court judge to declare if there hadn't been a decision?
No, I'm saying.
Does that make any sense to you?
So in the declaration case, we were asking them to approve or essentially journalize the agreement that was made in the prior case. That's what we were asking to be done in the declaration action. Okay. But at the time of the domestic relations hearing, we were asking the domestic relations court basically to enforce the parties' agreement. That's what we were asking the court to do. So the Akron court really wasn't being, the Akron domestic relations court was not being asked to essentially adopt a decision by the Akron court. They were being asked to adopt the agreement that the parties had made. Secondly, that there was some argument by the or a statement by the domestic relations court that the agreement was somewhat conditional. What happened was the parties actually made the agreement and began to carry out the terms of the agreement. We don't believe that the agreement was somewhat conditional, but only that those terms are essentially terms of the agreement themselves, and they were being carried out. The only possible conditions precedent that the court could have found were the three that were mentioned on the record when this agreement was read into the record. That is, that the wife would vacate the residence in a timely manner by September 16th, that she would turn in the keys to the husband, and that the property would be left in broom clean condition. Those, if anything, would be the conditions precedent, and they were carried out. So that's evidence that this agreement actually happened because the parties began to perform. She turned in the keys and she vacated timely. The issue of the leaving in broom clean condition, our client waived. He testified in the domestic relations court that he wasn't happy with the way the property was left, but he would waive that requirement and did waive that requirement. He never pursued damages. There's no judgment out there for damages. There's never been a hearing on damages to the property. He dismissed the second cause of action in the municipal court case, which was the action for damages. So that was waived. And then the other things were supposed to happen. There was supposed to be a dismissal of the domestic relations case, and the wife didn't dismiss. And we believe the trial court erred in failing to dismissed that case because that would have been upholding the parties' agreement. What's noteworthy is actually the wife's response to the motion to enforce that was filed in the municipal court case. In that response, the initial response to our motion to enforce the agreement in the first case in the municipal court, not the declaration case, she stated that she no longer felt that the contract, that she no longer felt that the no contact order was sufficient for her protection. That was the reason she gave for not wanting the agreement enforced. Really what happened was she just changed her mind. And there's all these precedents, especially in your district, that says you can't just change your mind when an agreement is reached.
When I read that transcript, am I going to see a agreement that judgment entries would be filed in both cases?
I think
was that one of the conditions that both of you agreed to
dismiss. So there should have been judgment entries of dismissal in both cases, for sure, or notices of dismissal in both cases. I do think it was contemplated that the parties would have a more formal written agreement that would be prepared, but that does not necessitate voiding the contract that was entered into. And again, the Santamoro case says that very thing, that the court should have enforced the agreement that was put on the record, regardless of whether the parties were able to subsequently agree on other terms or the details of a signed settlement release agreement. That's
Rich,
not the key part of it.
Excuse me, I just want to let you know you're into your rebuttal time. You're welcome to continue. I just wanted to let you know.
Okay, well, I'll reserve the rest of my time for rebuttal. Thank you.
All right, thank you, Attorney Rich. All right, counsel for appellee, Attorney Murphy, we'll hear from you.
Thank you, Your Honors. Your Honors, good morning. I'm Attorney Troy Murphy. I represent the appellee, WC, in the current matter. Your Honors, the fact is there was no enforceable settlement agreement reached in this case. Your Honors, in response to Your Honor's question regarding what will the court find upon reviewing the transcripts, what the court will find is that a very generalized list of items was entered into the record, and it was very clearly and explicitly stated that the parties would submit a judgment entry in conformance therewith. As we've briefed in our brief of appellee, there was no meeting of the minds on that particular day. That is evidenced by the fact that on, let me pull up the date here. There was an initial email sent by appellant's counsel to appellee with a draft settlement agreement. I responded on behalf of appellee to that draft and said, no, we're not agreeing to these certain things. So there were other things being added that weren't in this alleged oral settlement agreement that appellant would like to indicate was a binding settlement agreement on the record in Akron Municipal Court. We then received a second draft settlement agreement. Again, we responded that the additional terms and the terms that, quote unquote, if you will, filled in the gap were not acceptable.
Counsel, during
Yes.
all this time, did your client remain in the home?
Your Honor, she did remove herself from the property. The reason for that was a multitude of reasons. There was an underlying domestic relations case pending in the United Kingdom that had not been finalized at this point. So there were other issues with agreements that had been reached in that case, wherein she agreed to vacate the property within, I believe it was 60 days from a date certain in that order. I don't remember the exact dates, Your Honor. But there were a multitude of reasons why she vacated the premises. Your Honor,
let me just, because this meeting of the minds argument is interesting. Let me just quickly run through what my understanding of the agreement was. The agreement was that wife would vacate the property by September 16th. Was there an agreement on that?
I believe that was a portion of what was read in the record. Yes, Your Honor.
Was there an agreement that she was to leave the property in broom clean condition?
I believe that was also a term, Your Honor. Yes.
Was there an agreement that she was to return the keys to opposing counsel by the 17th?
Yes, I believe that was also one of
Did they both agree to a mutual no contact agreement in both municipal court and domestic relation court, and that judgment entries would be filed in both of those? Was that a mutual agreement, or is there?
Your Honor,
Go ahead.
Just to clarify, there was no agreement regarding any no contact order in municipal court because that matter was only before the Court of Common Pleas. There was reference to that. There was also reference to some other terms, but we were very clear that that a judgment entry would need to be drafted to fill in the gaps here. This was not all conclusive, given the fact there was a pending domestic relations court in the United Kingdom. There was a pending motion to show cause in.
Yeah, but wasn't there also an agreement that both parties would dismiss their actions? The eviction action would be dismissed and all motions and petitions in the domestic relations case would be dismissed. Was that part of the agreement or not?
Those terms were read into the record in Akron Municipal Court, but again, they were not all conclusive. There were. So what I think is telling in this case, Your Honor, is when we talk about pending actions that were pending in the Court of Common Pleas in the domestic relations action, it's ironic that after appellant was served with the motion to show cause against him, because there was in the domestic relations protection order case, Your Honor, appellant was ordered to pay $2,000 a month in temporary support. He had not done that after approximately 3.5 to 4.5 months. Hence why my client pursued the motion to show cause. Once he was served with that, he took a change of position, and that's when he actually filed his motions to enforce the settlement agreement. And what's telling, Your Honors, is included in our response to his initial motion to enforce the settlement agreement, and we've referenced this. It was attached as Exhibit A to petitioner's opposition to respondent's motion to dismiss and or enforce settlement agreement. Appellant's counsel actually sent an email saying, if your client does not intend to settle this matter and the other matters, I will send a discovery request. Appellant's counsel took the position that we still had to, there still needed to be this intent to settle the matter and under what terms. And if we weren't going to do that, appellant's counsel himself said, this is open litigation and I'll send you discovery requests. So he did not believe as of October 12th, that was of 2018, that was when he sent his email, that there was any settlement agreement, because he was telling me as appellee's counsel, then we'll proceed to litigation. It was only after they were actually served with the motion to show cause, that he then took this position that there needed to be an enforcement of the settlement agreement. Your Honors, we also take issue with the fact that as to the Akron Municipal Court portion, there was, it doesn't, even if the parties were to have in the court's mind reach their own settlement agreement, it still requires the court to accept the settlement agreement. The parties don't get to determine whether or not the court finds it amenable to a settlement and finds it fair and equitable to the parties. And Mr. Appellant's counsel filed his motions in both courts, Akron Municipal Court in 2 different matters, as well as the Court of Common Pleas. And the court that actually is alleged to have been the court where the settlement agreement was reached, which is the 2018 Akron Municipal Court case, the court found that there was no settlement agreement. That differentiates this from the matter of Santa Moro, where the court found that there were sufficient details read into the record. That case is very specific with what was read into the record. There was to be the transfer of property to 17 specific properties. there were leases that were specifically addressed to all 17 properties. There were security deposits regarding these 17 properties. There were rental payments. There were very specific settlement terms put on the record in Santa Mauro, which was not the case here. So that court decided upon a motion by the party seeking to enforce it in Santa Mauro that there was a sufficient record to adopt a settlement agreement. This court, the court that actually heard the settlement agreement, alleged settlement agreement, read on the record, said no. And in fact, the magistrate who was alleged to have heard it indicates in her decision of January 24th of 2019 that if, and I quote from her magistrate's decision, which was ordered into effect by the court, if the general discussion of the agreement were sufficient to dispose of all of the legal and factual issues in dispute, this formal written settlement agreement would not have been necessary. However, counsel for both the plaintiff and the defendant were aware of the complex legal and jurisdictional issues involved, as well as the fact that the Small Claims Court of Akron Municipal Court has no jurisdiction over matters being heard in the Court of Common Pleas of Summit County or the Bristol Family Court in the United Kingdom, and the parties agreed to formalize the settlement and then execute a settlement agreement specifically addressing these complex issues. It says the settlement agreement, the discussion of the settlement agreement on the record did not address all of the factual and legal issues involved between these parties in courts from Summit County to the United Kingdom. So this court reviewed appellant's submission and argument that it should be, a settlement agreement should be enforced. And unlike in Santa Mauro, where there were more specific terms, all-encompassing terms read into the record, the underlying municipal court here found that, no, we just had a generalized idea, but everyone knew there were very specific and complex issues given all these matters that had to be addressed. Your Honors, we also take issue with the fact that on a technicality, because appellant's counsel had actually filed a notice of appeal as to the original 2018 Akron Municipal Court case, and this honorable court sent that back saying, hey, there was no ruling on the second cause of action, at which time appellant dismissed his second cause of action, having already orally dismissed the first cause of action, and then refiled. And rather than referencing the prior case number, even though it was an argument of the same issues, trying to seek enforcement of the same settlement agreement, they file a year later in 2019, and it was only because Judge Larson became aware that there was a refiling that was originally assigned to a different judge, and I apologize, I don't remember the name of the underlying judge in the 2019 case to which the matter was originally assigned. But when Judge Larson became aware that there was a subsequent filing in 2019 on the same issues as he had addressed in the 2018 case, he entered an order transferring the matter to his docket. He asked the parties to brief the issue of whether or not this new case precluded litigation, the same issues being litigated that were brought to the court's attention in the prior case. And the court issued an order on September 28th of 2020, basically indicating that the court found it to have already been litigated and dismissed the action. So we find it that we believe that the appellant knew they were litigating the same issue. In essence, when they dismissed the first case, if you will, they were dismissing it under the savings clause with a year to refile, and should have refiled referencing the prior case number, and they didn't do that. Fortunately, our response to the initial complaint for declaratory judgment in the 2019 case, we brought to light this other case, and through the course of proceedings, it was transferred back to Judge Larson from the docket of the other judge. And again, I apologize, I was looking for that. I was hoping to inform the court of that judge's name, and I just, with the records in front of me, I don't have that, so my apologies.
I think it might have been Judge Walker.
That sounds right. I knew it started with a W, Your Honor, so I appreciate that.
No problem.
So Your Honors, it's our position that I think it's insincere for appellant to argue that they believe there was an enforceable settlement agreement, given the fact that their email response is 4 months after they allege that this settlement agreement was reached. 4 months later, they're saying, well, if we can't reach a settlement and the clients don't intend to actually settle the matter, then I'll send a discovery request. That notwithstanding, again, Your Honors, regardless of whether or not we believe the matter to be settled or not, it's still up to the court to genuinely determine whether they're going to accept a settlement agreement for purposes of resolving a case. And in this case, the court was very clear in a very well-reasoned decision that there was no all-encompassing settlement agreement. There were general terms that everybody knew needed to be filled in given the complexities of actions pending in 3 different courts in 2 different countries. And so
Counsel,
we don't.
can I pose a question to you?
Sure,
And I
yeah.
don't know if it's part of this record. I guess part is the lump sum that was ordered to be paid out of the divorce case in the United Kingdom. Was that paid? That's not at issue?
You're talking about, I believe it was approximately 60,000 pounds, Your Honor.
Yeah, I'm reading 35,000 pounds, but whatever.
Your Honor, I believe that, so there was an agreement made in the United Kingdom case where appellant would pay appellee a set sum. My understanding is counsel, I was not obviously counsel of record in the United Kingdom, Your Honor. My understanding is that there was payment made from appellant's counsel to appellee's counsel in the United Kingdom case. I don't know the specifics of if it was.
The reason I ask is it's my understanding that she was to vacate the property upon receiving that. So I guess I'm circling around to my first question I asked. Did she vacate the property upon receiving that? I'm assuming no, because the eviction was filed, but how long did she stay? Because she's saying there wasn't an agreement, but she stayed in the property.
Your Honor, I would be remiss to try and tell you whether or not she vacated in accordance with the UK judgment entry. And I know they don't refer them as judgment entries, but for lack of the actual term. But my understanding would be that if that was a violation of that order, then enforcement should have been sought through that domestic relations case in the United Kingdom. It would in essence be a motion to show cause or a motion to compel conformance with an order there. I understand they filed an action for eviction here. I'm presuming, Your Honor, and that's all I can do without the specific dates.
I understand.
I presume.
Counsel, I have to tell you, your time's up, but since
Okay.
I asked the question, if you just want to do a summary sentence or two, go ahead.
Sure. Your Honor, just to respond to your question in one sentence, I would presume that the filing of the eviction action is Your Honor presumes is probably correct. She did not vacate within the terms of that UK order. Your Honors, in my 2-sentence conclusion, again, I would just argue that there was no settlement agreement evidenced by the record and appellant's own statements that we would proceed to litigation. It was only after a show cause was served upon their client. And 2, notwithstanding, the court still would have had to accept it. The court found that there were not sufficient terms for a binding settlement agreement. Thank you, Your Honors.
Thank you.
All right. Thank you, Attorney Murphy. Attorney Rich, you have how much time, Judge Callahan?
4 minutes and 32 seconds, give or take.
There you go for your rebuttal.
Thank you. So yes, she definitely overstayed her visit. The time was dictated by the divorce decree. When she didn't get out, that was the reason for the initiation of the eviction action. And my client, the husband, forbeared and didn't force her out because we agreed on a date of September 16th for her to vacate, and which she complied with. This argument about the court, the first municipal court case should have been accepted or rejected by the court and didn't accept it. The court's only purpose in reviewing a settlement agreement would be determined if there was some kind of fraud or duress, and it didn't do that. The argument about there being there should have been a new filing. Well, my client didn't file for damages because he was carrying out the parties' agreement, which said he wouldn't pursue damages. He waived those damages that he claimed he could have pursued. Anybody could reject a written agreement. There's a million different ways to not like something in a written agreement. That doesn't void the parties' agreement that they put on the record, and it should have been enforced in both courts. The argument that there's somehow an attorney email about discovery, that email could have been about discovery, about the validity of the agreement. What has to be looked at is the parties' actions, not communications between counsel. And our client did what he said was going to be done, which is he didn't pursue damages for what he thought were the unacceptable conditions he was left with in the home after the wife vacated. Attorney Murphy raised the issue of these interim orders that were issued in the first municipal court case, but those orders are not res judicata. That case was dismissed, and those rulings have no bearing on the second filing or on the domestic relations case. The agreement is not complex. It is actually very simple. The agreement that was reached in the municipal court was the wife was to vacate, she was to turn in the keys, she was to leave the property in broom clean condition. There was to be a no contact agreement between the two parties that would be journalized in both the UK court and in the courts in Ohio. There was going to be dismissal of the municipal court case and the domestic relations case, and the parties would enter into a mutual release, including release for any liability for the past due spousal support. That's the case. That's the agreement. I don't know what the argument is, that it was somehow complex or that there were terms left out. What was left out? Where is the ambiguity in that agreement? It was very simple. Mr. Murphy was the one that stated it on the record for the most part at the hearing, and he did a very fine job. There's nothing that's not clear. And so
what was the basis?
There was no meeting of the minds. I don't believe there was no meeting of the minds.
What was the basis of the rejection of your first and second drafts? Is that where the ambiguity lies?
He didn't like the release language, something about the divorce case in England. There was some language in there regarding that he didn't think there should be there. But regardless, there should not have been a rejection by the court of the terms that were put on the record. The court should have entered an entry in both cases that enforce those terms. It was not about enforcing a settlement agreement that wasn't signed. The cases were both about enforcing the agreement that was put on the record. So the written agreement was not what we asked this court, asked the trial courts to enforce. It was the transcript that was submitted. It was submitted in both courts. It was typed. That's what should have been enforced. I don't understand the argument about no meeting of the minds. And the wife in this case performed her first two obligations, which were to vacate and turn in the keys. She did that in a timely fashion. That was the agreement. So those arguments really are not supported by the record, that there was some disagreement about terms or that they were ambiguous or that she didn't know what.
I'm sorry. I'll let you wrap up. Your time's up.
Okay.
So if you want to wrap it up in a sentence or two.
Yes, we would just ask this court to reverse both trial court decisions. We believe this is an enforceable agreement. And I would ask this court to look at the Haas case, which is also a 9th District case, and it cites to a case called Ellison, where they upheld an oral agreement that was read on the record, and also look at the other case that we cited. It's a Supreme Court case from like the 1970s called Spursell, where the parties were just in the judge's chambers and agreed in front of the judge on a settlement. And again, this is the Ohio Supreme Court case, and they enforced that agreement. It was just made in the judge's chambers. So there's a long history of courts enforcing agreements, just as the one that was made in this case. Thank you, Your Honors.
Well, I want to thank both of you, Attorney Rich and Attorney Murphy, first of all, for your patience with the court, and secondly, for doing a great job arguing this case. We'll take the matter under advisement and issue a written decision. The decision will be mailed to each of you, and it's also posted, of course, on the Supreme Court of Ohio's website. Again, I want to thank you. We'll be adjourned